A Supreme Court bench of Justices B.V. Nagaratna and Ujjwal Puyan asked this question at the last hearing. Petitions have been filed against the Gujarat government granting remission, allowing to walk free, reducing the period of sentence to all 11 convicts who had been sentenced to life imprisonment for multiple murders, violent sexual assault and the gang rape of Bilkis Bano during the 2002 communal violence in Gujarat. Should they have been allowed to walk free, given that the then presiding judge, U.D. Salvi, hearing the case after it had been transferred to Maharashtra, and the CBI had both objected to let all these accused of brute rape walk free? Who is Bilkis Bano? On March 3, 2002, Bilkis was gang raped and her 3-year-old daughter was among 14 people killed by a mob in Limkheda Taluka of Gujarat's Dahod district during the Gujarat carnage. Bilkis was only 21 years old and 5 months pregnant at the time. The investigation was transferred to the CBI from the Gujarat police and trial to a Maharashtra court by the Supreme Court. A special CBI court in Mumbai had, on January 21, 2008, sentenced the 11 to life imprisonment on charges of gang rape of Bilkis Bano and murder of 7 members of her family. The Bombay High Court on May 4, 2017 overturned the acquittal of 7 men, including policemen and doctors, and upheld the sentencing of 11 people convicted of rape and murder in the case. Moreover, it acknowledged complicity of state officials in the incident. On April 3, 2019, the Supreme Court had awarded Rs 50 lakh in compensation, a job and accommodation to Bilkis Bano, reparation which has only partially been realized by Bilkis. The decision of the Gujarat government came as a shock to all citizens, nationally and internationally. There was outrage, with protests, signature campaigns, all expressing anger, disappointment, distrust at the move of the government. On November 30, 2022, Bilkis Bano had herself moved the apex court, challenging the premature release of 11 lifers by the state government, saying it has shaken the conscience of society. It's also important to note that before Bano herself approached the top court, a number of petitions had been filed in the public interest challenging the Gujarat government's decision. The list of petitioners include Communist Party of India Marxist leader Subhashini Ali, Professor Ruprekha Verma, journalist Revati Lal, Trinamool Congress MP Mahua Moitra, former IPS officer Miran Chadda Borwankar, and the National Federation of Indian Women, NWFI. The hearing in the said case began on August 7th. The first question that Advocate Shobha Gupta, representing Bilkis Bano, put forth in the Supreme Court was whether men convicted for brutally gang raping Bilkis Bano and killing her entire family in front of her eyes deserve the leniency they have been accorded through remission. Shockingly, even before the convicts were allowed to walk out of jail freely, a decision that was announced on India's 75th Independence Day in 2022, investigation showed that they had enjoyed 1,000 days of parole while serving life sentences. Senior advocate Indira Jaisingh, appearing for one PIL petitioner, informed the court that the released convicts were garlanded and felicitated upon their release, and statements such as "Brahmins can't commit such crimes" made in response. Additional Solicitor General of India S.V. Raju for the Union of India had responded by asking what is wrong with garlanding a family member who comes out of jail, a comment that was quite brazen considering the gravity of the multiple crimes committed. Curiously, the court was also informed that convict Radhesham Shah had been practicing law after his conviction. The bench expressed surprise over this, asking whether a post-conviction license can be granted to a former rapist and murderer or not. Stating that law is supposed to be a noble profession, the Supreme Court judges added that even after convicts have been granted remission, they still remain convicts. During the hearing, the Gujarat government had batted for reformative justice of the convicts, to which the Supreme Court bench had asked, why is the remission policy being selectively applied? Even on August 23rd, the Supreme Court bench highlighted the issue of overcrowding, especially due to the under-trials languishing in jails, and why remission policy was not being implemented in those cases and only selectively here. The court had also said that the 2021 ruling of the Supreme Court, which allowed the Gujarat government to consider the remission applications, will not bar the judicial review of the remission orders subsequently passed. Judicial review is a process that examines the correctness of any decision reached by a public body. Do you support this decision of the Gujarat government allowing 11 men convicted of gang rape or enabling such an offence to walk free?